Companies Act Section 130 Reopening of accounts on orders of court or tribunal. The reliability and integrity of financial statements prepared and published by companies are essential to stakeholders, including investors, creditors, regulatory authorities, and the public at large. However, there may be exceptional circumstances where it becomes necessary to re-examine and revise past financial statements because they were fraudulently prepared or because the company's affairs were grossly mismanaged during the relevant period, thereby compromising the accuracy and reliability of those financial statements. Section 130 provides the legal framework under which a company's books of account and financial statements can be reopened and recast, but only upon the order of a competent court or the National Company Law Tribunal, NCLT. This power is extraordinary in nature and is not available at the discretion of the company itself. Reopening of accounts can only be triggered through a prescribed legal process. Prohibition on voluntary reopening by company. As a general rule, a company is expressly prohibited from voluntarily reopening its books of account or recasting its financial statements. This strict prohibition ensures that historical financial data once approved by the board, adopted by shareholders, and filed with the authorities is frozen in time, preserving the integrity of the corporate financial record. When and how reopening can be ordered. A reopening and recasting of accounts can only happen if the following conditions are met. 1. Application by an eligible party. An application must be made to a court of competent jurisdiction or the tribunal, NCLT, by any of the following parties. The central government. The income tax authorities. The Securities and Exchange Board of India, SEBI. Any other statutory regulatory body or authority. Any person concerned, such as a creditor, shareholder, or other stakeholder directly impacted by the financial statements in question. 2. Grounds for reopening accounts. The application must establish one or both of the following grounds. The financial statements for the relevant period were prepared fraudulently. The affairs of the company during the relevant period were so mismanaged that serious doubts arise about the reliability and accuracy of the financial statements. Procedure to be followed by court or tribunal. Before granting an order for reopening and recasting the accounts, the court or tribunal must follow a fair and transparent process by issuing a formal notice to the central government, the income tax authorities, the Securities and Exchange Board of India, SEBI, any other concerned statutory regulatory body or authority, any other concerned party that may be affected. Considering all representations made by these parties before making any final order. This process ensures that all relevant regulatory agencies and interested parties have an opportunity to be heard, and the decision to reopen accounts is made only after full consideration of the facts, evidence, and representations. Finality of revised accounts. Once the books of account are reopened and the financial statements are revised or recast in accordance with the order of the court or tribunal, such revised financial statements shall be deemed final and shall supersede the originally filed financial statements for that period. This means the revised accounts replace the earlier ones in all respects, and the company, regulators, and stakeholders must treat the revised accounts as the definitive record for that financial year. Time limit for reopening of accounts. General Rule 8-year limitation. Ordinarily, a court or tribunal cannot order the reopening of accounts for a period earlier than the 8 financial years immediately preceding the current financial year. This 8-year limitation period reflects the general statutory record-keeping requirement under Section 128 of the Companies Act, which mandates companies to preserve their books of account for a minimum of 8 years. Exception: extended period under government direction. There is one exception to the 8-year limit. If the central government has previously issued a direction under Section 128(5), requiring the company to maintain its books of account for a longer period, due to an investigation or other exceptional reason, the court or tribunal can order the reopening of accounts for this longer period. This exception ensures flexibility in cases where a company's longer financial history needs to be re-examined due to the nature or severity of the suspected misconduct. For more details, contact us.